This video will discuss 10 more issues with HR1280, also known as the George Floyd Justice and Policing Act of 2021. This is the bill that passed the House of Representatives and that President Biden mentioned in his first address to a joint session of Congress. I previously did a video on this bill's potential impact on qualified immunity, and if you'd like to see that, check out the link above or in the description below. I'm Steve Serbalik. I'm a panel attorney with ASCOPS in Arizona. Here's the first issue. It changes the legal definition of deadly force to something that goes well beyond the plain meaning of that term. Normally, we think of deadly force as force that's likely to cause the death of another. For example, shooting somebody. The bill changes this definition to include many different tactics, including, quote, multiple discharges of an electronic control weapon. This is a serious problem, as tasers, the most common electronic control weapons, are often not effective the first time that officers try to use them. Tasers only provide full body incapacitation when the probes are correctly spaced apart, something often beyond the officer's control. So, if the very first taser shot isn't effective, any further taser use would be considered deadly force under this legislation. Second is the new legal definition of use of force. Normally, we think of a use of force based on the common meaning of those words. Officers actually engaging in some type of physical interaction with a person. The law expands this definition to include, quote, any intentional pointing of a firearm at an individual. This is a problem, as officers often point guns in uncertain circumstances. For example, when they pull over a car that was reported stolen, or when they are clearing a house or a building where an alarm is reported. Under the new law, officers would be discouraged from having their guns out in these potentially dangerous situations, as if they pointed their gun at a person, they would be deemed to be using force against them. Third, the act subjects police officers to potentially facing a life sentence in prison for on-the-job conduct if their actions result in the death of another. Right now, the law allows for the conviction of police officers only if they willfully cause the death of another under the color of law. The proposed change would substantially lower that standard to reckless, which is way lower than willful, and also changes this standard to allow for a conviction if the officer's actions were a substantial factor contributing to a death, even if the officer's actions were not the actual cause of death. Fourth, the act allows for state attorneys general to initiate legal actions against local police departments to attempt to secure consent decrees in federal court. Previously, these types of consent decrees were only available to the United States Department of Justice. But under the new law, any state attorney general could attempt to secure these same powers in federal court against local agencies. The new law also provides for federal funding of these new state attorney general proceedings against local police departments. Fifth, the act would force officers to report the race, ethnicity, age, and the gender of the officer and civilians involved in all traffic stop violations, pedestrian stops, frisk and body searches, and instances where officers use deadly force. In other words, officers would be forced to ask everyone involved in a law enforcement stop what their race and ethnicity are, and the statistical data would then be reported to the federal government. Agencies failing to report this data would lose significant federal funding. Sixth, there would be a new federal database created that contained all complaints filed against all police officers, whether or not these complaints were sustained. Seventh, in every single deadly force case, and in every case when any force was used in arrests or bookings, agencies would be required to report the national origin, sex, race, ethnicity, age, disability, English language proficiency, and housing status of each civilian against whom a use of force occurred. The law offers no clarification as to how officers would get some of this information, or what standards would be used so an officer can objectively determine someone's English language proficiency or disability. All of this data would be made public by the U.S. Attorney General. Eighth, if interviews, traffic stops, pedestrian stops, and searches by a department occur more often for one racial or ethnic group than another in a given jurisdiction, this would be considered prima facie evidence of illegal racial profiling. In other words, if departments conduct more stops and searches in high crime areas that happen to have a racial makeup different than the city as a whole, the department could face a federal civil rights probe and a resulting consent decree. Agencies found in violation of this provision would also be forced to pay a prevailing plaintiff's attorney's fees if sued under this section. 9. Officers wearing body cameras would be required to obtain consent to be recorded from crime victims or witnesses before interviewing the victim or witness. In other words, officers who want to ensure transparency and potentially to protect themselves from allegations that a witness might make against an officer must turn off their body camera if the witness does not provide prior consent to being recorded. Failing to follow this procedure could result in substantial reduction in federal funds available to local departments. 10. A categorical ban on no-knock warrants. Regardless of the danger faced on a premises, no police agency would be able to ask for a no-knock warrant from a judge, or that agency would forfeit substantial grant money provided under the federal COPS program. So there are 10 more issues with HR 1280. Issues that you don't hear discussed or considered, but that people concerned with effective law enforcement should definitely know and understand. As a general rule, I don't make videos on proposed legislation, as much of it doesn't pass or is heavily amended. But this topic has come up quite a bit, so I thought that it might be useful to examine some of the language as it initially passed the House. If you found this video helpful, please hit the like button below and subscribe for more law enforcement lessons. Videos are posted every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.